is where the conversation around getting involved in the foundation is happening, so in the Kane room. And with that, I'd like to introduce this Planning Ahead Special Needs Trusts and Conservatorships. So Julia Dean is, we're pleased to have Julia Dean join us. Ms. Dean's professional experiences encompasses a broad range of legal matters. Her primary emphasis are civil appeals, estates, planning, and probate. Her estate planning practice involves helping clients orchestrate their estates by drafting a vast array of trusts, wills, and powers of attorney. Ms. Dean also provides compassionate legal advice while assisting families through the probate process. We are extremely grateful to have you join us today. Please join me in welcoming Julia Dean to the stage.
Thank you so much. I appreciate it. It's such an honor to be here, and I thank you for coming and investing this time. It's our passion to work with special needs families and individuals and to help with estate planning and intermeshing those together. I recognize with you being here that you have just such an internal strength. Dealing with your child, there's a lot of challenges, but there's a lot of great, intense joy in the midst of that. And so I feel honored to be here to assist you in any way I can. I know you play a role as an advocate, and you also have passion to protect your own child. You have a passion to see your child thrive and be as independent as possible. So before I go into really the meat of this, I did want to introduce my team. And so right here in front, if you could stand up and wave, this is Laura Bromlow. She's an attorney that is a certified elder law attorney, which also means not only elder law, but special needs trust. So when we say elder law, we also mean special needs. And that's what a lot of people don't realize. So if you're looking for an attorney that specializes in this, you're looking for an elder law attorney. She's also licensed in several states. She's licensed in California, in Florida, in Kansas, and in Missouri. I have another attorney that's licensed in Kentucky, Tennessee, and Texas. And then I have another attorney, Julia Pullen. Is she? There she is. She's standing up in the black. She's waving. She's also another Julia, so we call her Jules. She's out of law school about a year, and she's an excellent attorney, and we're just so proud to have her. Then I have a couple of team members here with me, not the whole team, but in the red over here, that's Regina, if you'd wave. Regina Gabig, she's our office manager and bookkeeper. And next to her in the black, if you could wave Cindy Breton. She's our client intake specialist and our marketing director. So I have watched my sister with her child, who's autistic child, high functioning, but I've seen the challenges that she has gone through in trying to really integrate her child into the community, into school, and with administrators, and she has to really become the advocate for her child. I've also seen her do just what you're doing right now, being at conferences to learn practical ways to deal with things, the legal aspects of everything, and how to really understand her child to be her best advocate. What I have seen is that although she's high functioning, it's the social aspects that she has trouble with. And so loud sounds or just being in a crowd of people, even though she's very smart, has made for significant challenges. And she tries to cope with it by doing acting, and she kind of goes into an acting role. So she did get into college, but the first college kicked her out because they found out she had some emotional challenges and sought help for it. And so she was really knocked off her feet because she was doing well in school. And I saw her have the tenacity to get back up and try again. And so she did. And she went to a vet tech school. And then at the vet tech school, she got all the way to the end, and she did her externship. And she had trouble with the parents. She was great with the animals, but she couldn't relate to the parents. And so they let her go. And so she could never finish that. So then she went to Northern Arizona University and she tried biology, decided to switch to teaching, and she got her teaching certificate, and I saw her graduate a year ago in May. And as we were sitting there, we couldn't believe she had been through so long, so many years of college, and so many times of trying, that there she was, and we were just so happy she was graduating, and we were so happy for her. And the president of the university, Northern Arizona University, got on the stage, and we saw her honor my niece. And there was her picture and all she had done, and they recognized how hard of a journey it had been for her to even get to the place of graduation. And there wasn't a dry eye in our family, for sure, because we knew it really had been that way. So she's struggling now still to, find her place in the teaching world, because there's a lot of noise, there's a lot of change, there's a lot of parents, and she's trying her best. So I know it's a constant struggle. And I know these kids, they have amazing tenacity to get up and keep going, and they have a great courage. But you do too, as a parent. And that's awesome, and I just want to commend you for that. So one day in their life, everything's going to change. They're 17 years, 364 days old, and you have all the rights legally to handle everything for them. You make their medical decisions, you make their financial decisions, you make their living choices, but then all of a sudden they turn 18 and you've lost that. I came to a startling reality that that is the truth with my oldest child. Now you would think, being in this field, that I would have really been right on it, day one. No. Okay, let me see. Is there a better way to switch this? Aha, it's the bottom. Okay. All right, so my daughter is in college, my oldest daughter. She's just barely in college. I get a phone call from her roommate that there's been a terrible accident. Somehow she found out about it, a motorcycle accident. My daughter has never been on a motorcycle before. And my daughter was hurt, is in the emergency room, and the boy she was with is injured, and they're not sure they're going to make it. But she doesn't know any details, and I can't get a hold of the doctor, and I don't have a HIPAA agreement, and I don't have a medical power of attorney. Can you believe it? I don't. Because I had been taking care of all of that, and I forgot that on the day she turned 18, I needed to do something more to protect her, to protect me. So instead, I'm frantic for about 2 hours until she comes to enough to tell the doctors, yes, please talk to my mom. It's okay if you talk to her. So finally, I get a call from the doctor, and I find out that she's about to go into surgery, and she's 5 hours away. And the boy she's with, now she's married to, of course, that was a little rocky for a while, as you can imagine, but it was their first time they had gone out on a semi-date, and they were just going to get copies for their school college paper. They both went through a lot of surgeries. Fortunately, they both made it. But I understood then that this is a really serious thing, and for you all, it's even more serious. Because you need to be able to make those medical decisions for your young child that's just turning 18. You need to be able to decide where they live. You need to be able to take care of their financial decisions and make decisions regarding government benefits or other things for them. So when we're planning ahead, we need to think about how do we integrate your planning as a parent for your child with your own estate planning. So we need to look at, of course, what we need to do for your child. And so mainly we're going to be looking at guardianships, and I'm going to go into detail on guardianships. Now in some states they're called conservatorships. That's the same thing. So when I talk about guardianships, because that's what they're called here in Texas and what I'm used to, you can just think conservatorship if that's in your state. And then we're going to be looking in detail about special needs trust. So we want to make sure that their money, or any money you give them, isn't disqualifying them for government benefits that are so important to them, especially their medical benefits. And then we're going to also be looking at your estate plan to make sure that what you're doing is coinciding and integrating with their own, what we did for your child, so that we're not disqualifying them when you pass away. So basically what we're going to be looking at is guardianships. As you can see, we're going to talk about other aspects that may be available to your child if they have more capacity, powers of attorney, and other kinds of assisted decision making. And then we're going to be talking about special needs trusts, the different kinds of special needs trusts and what they entail, and just some of the critical aspects of that, so that you have a general understanding of special needs trust. And then we're going to be talking about how do we include your child in your estate plan, and then some other ways that maybe we can provide for our child, if that are alternatives, ABLE accounts, or some other kinds of ways that don't require necessarily a special needs trust depending on their situation. And if we have time, we're going to get into it some and in more detail, if we do have some time, about SSI benefits and other needs-based benefits, so that you have at least a general understanding. Each state is a little different, but we want to make sure you do have that understanding of what might be available to your child. So we know how important it is to have, for you to help your child be independent, have autonomy, to be able to thrive as much as they can on their own. We also have to look at how the law looks at that too, though. Do they have the legal capacity to handle some of these decisions? So assuming they don't, then we need to make sure that we are getting a guardianship in place. Now, there's different kinds of guardianships, but a guardianship is a court-ordered process where they appoint, say, the parent as a guardian over their child. So the child is called a ward because the state is looking over all of this and making sure that you're taking care of your child well. So that, then they'll also be looking over their financial aspects if it's going through the guardianship process. So the legal definition, you can see it up there. This is what the courts will be looking at. The judge will be deciding based on this definition, at least in Texas, and they're pretty similar throughout the states. Is your child legally incapacitated? And that doesn't mean they can't do some things. It could be a partial incapacity, or it could be a total incapacity. But it's a person who, because of physical or mental condition, is substantially unable to provide for his or her own food, clothing, and shelter, or to care for his or her own physical health or manage your personal financial matters. And so in Texas, and I'm sure in most other states, this requires a doctor certificate. They may call it different things, but a doctor has to determine this. And they will, in Texas, will go through and say everything, what they can and what they can't do, what their prognosis is. And so if they come to the decision that they're partially or totally incapacitated, then that's when we can get a guardianship for your child. Oops, went the wrong way. Okay, so there's two main kinds of guardianships. There's a guardianship of the person, and there's a guardianship of the estate. Now, the guardianship of the person is to handle the medical decisions. So you can look at medical documents. You can make medical decisions for your child. You can plan for that. You can plan for where they live. And you can decide just everything but their financial kinds of things. And if it's a full guardianship of the person, then you have all rights to do that. There is an annual report of the well-being of the child in Texas, and probably something similar throughout the states, where every year you submit that to the court to determine, so they know exactly what their medical condition is, where they live, Are they thriving? Are they seeing the doctor? Are there certain things that need to be attended to? So they want to make sure that the child is not being neglected in any way and is getting excellent care. The guardianship of the estate is different. It's only for financial matters. So sometimes we can have a guardianship of the person and avoid the guardianship of the estate by utilizing special needs trust or other methods. So that's why special needs trust planning is so important, because guardianship of the estate is the most time-consuming, expensive kind of guardianship there is, because everything has to be monitored by the court. We have to prepare a budget, a monthly budget of everything. If you go outside that budget, then you have to ask the court for permission to do something for your child, or to buy something, or sell something, or make investment decisions. So all of that is monitored by the court, and every year there's an annual report that has to be an accounting that has to be filed. And so not only do we have the annual accounting, like we have the annual report of the person for the guardianship of the person, but now we have all these other requirements. There is a bond with either kind of guardianship, but guardianship of the person is usually pretty minimal. We've seen as low as $10, and usually $100 is kind of the max. But guardianship of the estate, they're going to be looking over how many assets that child has. So as we talked about, it can be full authority or it can be limited authority. Full authority would be if they were unable to care for themselves, if they can't manage property, if they can't drive a vehicle, if they can't vote, make marriage decisions, those kinds of things. And so the court will specify what they can and they can't do. So maybe they decide, okay, they can drive a car and they can vote, but they can't do other things, and they will specify that. So the process is there's an application that's filed with the court that has all the information about your child, and we also submit it with a doctor's report that's from your doctor stating what your child can and cannot do. And then we can do this as early as about 6 months, 180 days, prior to when your child turns 80. I highly recommend that you do that, because it takes about 6 months to get a guardianship in place. I think the quickest we've seen it is 3 or 4 months, but it can be as long as a year. So we really want to get them in quickly. And so to start the process as soon as you possibly can is so important. There will be a hearing, but prior to the hearing, there's going to be some investigations. So you'll see here that there's a guardian, attorney ad litem that's appointed. This is someone who's appointed for your child. They advocate for your child. Well, your child tells them, I don't want a guardianship, or I don't want mom or dad to be a guardian, or whatever. Well, they're going to advocate for that. Doesn't mean if it's in their best interest or not. So sometimes the court will also appoint a guardian ad litem. A guardian ad litem is usually an attorney as well, but someone who advocates for what is in your child's best interest. And in Harris County, if there's anyone in this area, as opposed to Fort Bend County, they also have a court investigator. So you may have something in your jurisdiction similar to this, where before they even allow for the application to move forward, they would have to appoint a court investigator who would go out to the house and to see the circumstances of your child and you, and whoever wants to be the guardian. They will talk to the doctor, they'll go through all the medical reports, and they'll make a recommendation to the court on whether or not this guardianship should move forward. And believe me, if they say it shouldn't move forward, it won't move forward. So that's a really critical kind of piece of this, and to be very cooperative in what they want so that we can get a yes, we need this. Then we get to a hearing. So once all the ad litems and the court investigator are all on board, then we have a hearing that's set. Now the child can be there, but if the doctor says it's not in their best interest to be there, which is generally the case, they don't have to be there. And usually it's a confusing process for a child to be in front of a judge with everything, but sometimes it's a very helpful thing. So, it just really depends on your child. And at the hearing, there will be questions asked of you wanting to be the guardian. And there would be questions asked by the attorney ad litem and the guardian ad litem. And then they would the judge would decide, usually then, sometimes they'll take it under advisement, but usually they'll make a decision then whether or not you should be a guardian and the bond that should be set. And then you have a certain amount of time to get the bond and to be qualified and take the oath of a guardian. And then you will receive what's called the letters of guardianship. This is your authority to act. This is a piece of paper that you've been waiting for through this whole process. Before then, you can't do anything. With that piece of paper, you can do everything. And as a guardian of the person, you'll be making all their medical and their living decisions. As a guardian of the estate, you'll be making all their financial decisions. So is age just a number? Well, it's a very important number. And so some of the options that we can do, if your child does have capacity, legal capacity, to understand what they're doing and to hold that long enough to sign a power of attorney, then we can avoid the guardianship process with a medical power of attorney. If they know who they want to make medical decisions with, then that would allow them to choose you or whoever to make their medical decisions. With a financial power of attorney, they are appointing you or someone else to make their financial decisions. And you still want to probably do some trust planning, and we'll go into that, but this is going to help avoid the guardianship of the estate as well as the special needs trust planning. There is supportive decision making that's available in some states where maybe they can make decisions along with the help of you or someone else on their medical decisions. And a representative payee with some of the needs-based government benefits or other government benefits, you can be appointed as the representative payee. And that may be all you need in certain circumstances. Maybe you need more. So planning, we're looking at the road ahead. What happens? Right now, you're taking care of your kid and you're fine and everything's great, but what happens if you're incapacitated? What happens if you pass away? You know, we hate to think about that, but we don't ever, if we deal with it now and we pre-plan proactively, then when you're done, believe me, you're going to have such peace of mind knowing that there's a plan in place for your child. So the purpose of planning is obviously to make sure they have enough funds. And sometimes, even in the trust planning, we might want to think about life insurance and funding life insurance into the trust. So when you're not here, there's a pool of money that can be used for their care because you won't have that income stream coming in anymore. And just we want to make sure their quality of life is really good, as best as it possibly can be for them. So the benefits of planning, you'll see many here. Obviously, we want financial security for your child, that there's enough to last them through their lifetime for all their needs. We can leverage, by planning and doing some trust planning or other planning, we can leverage your estate and their money to really get better needs-based government or other public benefits. We can, at the time of planning, select a care team for your child. And so that's a wonderful thing, because then you can think about the people who really know your child and love them and would want to advocate for your child, but maybe they're not the right person to handle the finances, but they can give input into this. So having that team around your child when you're not here to advocate for them is a huge benefit to them. We also want to plan for their housing needs. What's appropriate housing for your child? Is that living at a home, a private home? Is that a group home? Is that a living situation like here we have Brookwood, where it's an adult community for those with special needs, and they have work they can do, and they have education, and there's a chapel, and there's other things there, you know, that are available to them. So there's all kinds of different options. But if your trustee doesn't know, or the person who's taking care of your child doesn't know what you want, they can't implement what you want. So planning for that is really important. And I always recommend whatever you do in your plan, your trust, your will, your special needs trust, do a letter that you can update that talks about your child. What does your child like? What medications are they taking? How often do they take it? What triggers a bad response from them? What triggers great responses from them? How do they learn? I mean, there's a whole bunch of things that you can put in there, but if it's a letter, then you can update it because things change all the time. But it's something you want there because if someone's coming in, especially like a corporate trustee who may have no idea what they need and they're going to have to learn, this is their guidebook, and it's a wonderful personal guidebook that you can give them. It provides for a system of ongoing advocacy because you have a trustee or someone that's appointed to be their advocate. You can plan for caregivers that they might need in the future and what kind of caregiving you would want. You want to coordinate with the extended family. If they want to give money, how they give money to them to help out. How do they help with their other needs? That's going to be really important to think through. You're going to protect them from predators that are out there. Unfortunately, we wish the whole world was wonderful and we could trust them all. And, you know, oftentimes our children will just implicitly trust people. And unfortunately, there are a few bad people out there, and most of them are good, but there are a few that might take advantage of them. So having it in a trust or something else that's protected and we know who the person is that's taking care of it, or it's a corporate trustee who's bonded, those kinds of things will provide that sense of protection for your child from predators and preserve the assets as they go on to other generations if there's anything left. So what not to do? What we don't want to do is give inheritance outright. That will immediately disqualify them for any kind of needs-based government assistance like SSI and Medicaid. Plus, they're not in a position to really handle those finances well. We have no asset protection around it. It's available to predators, it's available to creditors, and if they do get married, it's available to be split in a divorce. We don't want to leave it in what we call a non-qualifying trust or not a special needs trust. What's called a general needs trust. And I'll explain that a little bit more later, but we want it in a special needs trust so that they can be sure that they will qualify for those needs-based benefits. We don't want to disinherit them. They need that money. They need those funds to help them through. And we don't want to leave assets maybe to a brother or sister or aunt or uncle or someone else, because now that's part of what they have, and they can use it on themselves. There's nothing that prevents them from using it on themselves or their families. Maybe they get tired of taking care of your child and decide to not take care of the child. It is subject to their creditors as well. So if you give it to them and outright and they can use it for your child and they get sued because they're in a car accident and it goes beyond their auto insurance policy, well, guess what? There goes that money because it's non-exempt money. So we want to protect that money so it lasts through your child's life. That's going to be so important for your child. So, you know, if you die, we want to make sure that you have taken care of your children in a way that best protects them. And also, if it goes to someone else outright, it could be lost in divorce as well. So now I'm going to talk about different kinds of special needs trust. I've alluded to them a lot. There's two main types of special needs trust. There's a first-party special needs trust. That means it's a child's own money. Sometimes we call it a self-settled special needs trust. We have a third-party special needs trust. That's everybody else's money that can go into a third-party special needs trust. And there are pooled trusts out there that we'll talk about a little bit. But the main two types that we're going to talk about are the first and the third-party special needs trust. Okay. I think of trust like a bucket. So everyone who's come into my office sees my bad drawings of buckets. And the reason why is we're taking your assets and we're putting them into that trust bucket. And so here we're putting, for the first party special needs trust, we're putting the child's own assets. It's the only thing that can go in there. So that can be maybe they have money that people have given them and gave them outright and shouldn't have. Maybe they have money from work. Maybe they have money through injury settlement or some other method. But their money would be what's going into the first party special needs trust. The difference between this one and the third party special needs trust is that upon their death, we have to pay back the state. Here, the state of Texas for Medicaid benefits up to the amount of benefits that they received. With the third party special needs trust, we don't have to do that. So with the third party special needs trust, now we're putting everybody else's assets into that, but it doesn't have to go back to pay the state. So we want to fund that, you know, and I usually recommend a standalone trust that we can fund it now during our lifetime. So if grandma passes away and she wants to give some, she can. Maybe she wants to make gifts now. Maybe you want to make gifts now. Maybe a cousin or an aunt or uncle or a friend even wants to contribute to your child. This is how they do it, is through a third party special needs trust. So with the first party special needs trust, now remember that's the child's own money. Reason why we usually have to set it up, as I mentioned, is like a personal injury settlement or litigation proceeds from that settlement, or just poor planning. Unfortunately, then they get the money and now we have to do something with it. And so that money goes into the trust. They can become qualified for Social Security income or SSI or Medicaid, but they have to pay that money back to the state if there's anything left. It's created, it can be created now by the special needs individual themselves if they have mental capacity. So that's a pretty new law. Otherwise, the parent, the grandparent, the legal guardian, or the court can do it. So that's why it's so important you intervene now, a parent or grandparent do it, because we don't want to have to go to the court and get the court to do it, because guess what? That's expensive and it takes time. And so we can't do it really quickly. We can only do this too while the child's under the age of 65. So otherwise we lose that ability to put it into a first party special needs trust. And then it would allow for eligibility of the needs-based government benefits, SSI and Medicaid. Now, third-party special needs trusts are created by any person, a loving family member, or someone who really cares about your child. I recommend that you do it now so that people can start gifting now, because others contribute to that and it maintains their eligibility. And this is where you want to direct your own inheritance, your own legacy that you're giving your child, is through the third-party special needs trust. We can put in the trust legally binding instructions for the trustee or your care team that they have to follow. And so it's a guidebook for them. And it's really important document, not just to protect their money, but to tell them how you want it to go, to help direct it, to provide for your child in the way that you would want them to be provided for when you're not here. So not only are we preserving eligibility, but you're appointing a lifetime care team, as we talked about. You're directing that care, and you're providing advocacy right there because you've provided the advocate. So in selecting your care team, as part of the trust, you're going to have a trustee who's managing the money and the investments and making the distribution decisions. That can be an individual, someone you trust. It can be yourself to begin with as a parent. Or it can be a corporate trustee or other professional like a CPA or an attorney. I would really recommend, if it's not a family member, that you find a professional who deals with special needs trust. There's a lot of corporate trustees that have really learned this area of the law because of all the different laws that are out there for qualifications of the special needs benefits. It's important that they understand that so they're not doing something to disqualify your child. So sometimes it's worth the extra cost to have a professional do it, if you don't, especially if you don't have someone that you trust and to really understand that. But an individual can get advice from an attorney or CPA on what to do. Now, there's a trust advisory committee. It's called different things, but basically there's an accountability check on your trustee and to help them just to have some advice on how to handle your child. And then a trust protector, and that's something that I put in actually all my trusts because I feel like it's so important. Whether you name them then or you name someone who can appoint someone later, what it does, it allows for flexibility in an irrevocable trust. And it allows them to go ahead and to maybe the laws change. So if the laws change, we need someone who can come in and make changes to your special needs trust. So now they stay qualified for benefits, and if there's an ambiguity there, to make clear what it is. And then we can do this to the trust protector, which I usually recommend as an attorney experienced in this matter or a CPA experienced in this area, to make those changes without having to resort to the courts. Again, every time we go to the court, then there's more cost involved. So that's another reason why it's so important to get the trust planning, because once you have your trust in place, we can avoid the guardianship of the estate, as I mentioned before. Your trustee's responsibilities are to invest or manage those assets for the best use of your child. And so generally we recommend that it be a very conservative kinds of investments so that we're preserving that capital for your child. They distribute the funds as needed, but they never distribute it to your child. What they do is do it for the benefit of your child to help pay for things that they need, and they'll see all the terms in there. They'll keep the books, make sure that they're keeping accounts of everything. There is an annual accounting that is required in Texas. We cannot waive that, and I'm sure it's probably the same in most states. They file the tax return. They can hire advocates and care managers, bookkeepers, whatever they need to do. They are under the highest duty under law. Whenever you have a trustee, they are a fiduciary. A fiduciary is the highest duty there is, to do everything in the best interest of your child as a beneficiary. They need to invest those funds with them in mind and their needs in mind. They need to have a duty of loyalty to them. They can do nothing for their own benefit. It always has to be for the beneficiary themselves. So there's very specific language within a special needs trust, and that's why it's so important that you utilize an experienced attorney that knows special needs trust. Because if they get it wrong, you lose eligibility for your child for the needs-based government assistance. But part of the things that have to be there, and this is not all of them, but just a highlight, is that the beneficiary cannot ever have the right to revoke this trust. Now, other people can, like you or someone else, but not the beneficiary. And the beneficiary can never be the trustee of this trust. The trustee must have absolute discretion on distributions. And I recommend, as I mentioned before, a standalone trust so that other people contribute it and that we can fund things into that trust bucket properly and utilize other people's money to help your children as well. There is a pool trust that is usually run by charities, and depending on your child's circumstances, this might be a good one. If there's not a whole lot of money, we can put it into a pool trust that's shared with other people. It's accounted for your child, and it can be used for your child's needs, like a special needs trust. The problem is there's a payback provision. So if you're putting your money in there, anything left would go to the state where your child is getting benefits to repay up to the amount of the benefits they've received over their entire lifetime. But if we take our own money and we put it into that third-party special needs trust, there might be money left over, and hopefully there will be, and then that can then transfer down to our other children or other heirs. We don't have that option with a pool trust, but for some people this is a really good option. So as I mentioned, planning ahead requires the integration of how we're planning for your child specifically in the guardianship or in a special needs trust or a pooled trust, and also your own estate planning. So as we're looking at your own estate planning, we're looking at making sure that any legacy gifts that are given to your child go through that third-party special needs trust. A third-party special needs trust can be a standalone trust, which is what I usually recommend so we can gift along the way, but it can be a testamentary special needs trust that is just funded upon death and created upon death, so all the terms are there maybe in your will or living trust. But that subtrust, the subtrust that's a special needs trust, is a testamentary one that creates upon your death. And then there can be special needs trusts within other trusts. So sometimes we're doing more advanced planning like retirement income and trying to make that really multiply and be a legacy for your special needs child. We can do a special needs trust within that retirement inheritance trust that provides them with the best benefit possible, giving them a multiplication, really an exponential kind of gift to them. So with your own plan, we talked about the third-party special needs trust, and I'm going to talk about a separate lifetime trust for your children. So we set up with, here's a husband and wife, and then we have a son who's special needs and a daughter who's not. So we want to make sure that when it goes to, and you'll see there, right here, oops, I turned it off. There we go. See how it goes from, say, husband passes away first and it goes to the wife. And then when it goes down to the children, say it's going half and half, for the son who's special needs, it's just going to be a direction into the third-party special needs trust that has already been created for them. Then for the distribution to the daughter, since she doesn't need a special needs trust, I would recommend a separate lifetime trust. That would give that money asset protection around it, and it would give divorce protection so that couldn't be lost to a divorce and split by a divorce court, and it would stay out of their own estate for estate tax purposes, which is another conversation. But there's a lot of protections having money in trust, even if they're wonderful with their money. If they're not, even more reason. But if they're wonderful with their money, they could be their own trustee and just have provisions for a co-trustee to be appointed if we have a creditor or a divorce situation. I wanted to show you that just to show you how we might integrate a special needs trust into the planning, or we can do a testamentary special needs trust. There could be a lot of other planning, but this is just kind of some of the basic planning that we would put inside of a will or inside of a living trust, which is a revocable trust that could be avoid probate altogether. So I had introduced Laura Bromlow. She is my attorney that is getting her license here, but she is licensed in California, Florida, Missouri, and in Kansas, and she joined our firm in July. She is a certified elder law specialist, so this is her prime area. And I want her to talk to you about some of the public benefits that we have, and then I'll join you back at the end.
Okay, thank you, Julia. So just to kind of put this all in context, the whole reason we've been talking about special needs trusts, that Julia has been telling us about them, is because we want to preserve some public benefits. There's other reasons for special needs trust, as she discussed, but when it comes to public benefits, there are really two main kinds, two main categories, okay? There are needs-based benefits, and there are what I call entitlement benefits. Entitlement benefits are something that all of us are entitled to. So when you turn 65, you're entitled to receive Medicare. Two other entitlement benefits would be Social Security Disability, SSDI, and some special education. Those are a few of the entitlement benefits. So when we're talking about special needs trusts, we're really talking about preserving those needs-based benefits. The needs part meaning financial need. So this is for people who have a financial need. The main one that you hear talked about is SSI. This has a financial need component to it, as does Medicaid and the rest of those that are listed. The one that I want to talk about mostly is SSI, and the reason I want to talk about it mostly is because, as Julia briefly mentioned, Medicare or Medicaid is such an important benefit to individuals who have special needs because they need the medical insurance that Medicaid provides. And SSI, if they're eligible for it, will, in most states, not all states, you got to check it out, but in most states, SSI eligibility is going to give them automatic Medicaid eligibility. So to receive SSI, there's two tests, okay? There's the medically disabled test, and then there's the financial need test. So the definition of disability for SSI purposes it's up here, you can read it, but basically it has to be a medically diagnosed impairment, either physical or mental impairment, and it has to impact that individual's ability to engage in a substantial gainful activity. So when your child or your loved one with a disability goes to apply for SSI, they have to prove this medical disability. So they're going to have to either show their medical records, get a doctor's certification, something like that to prove that. The financial component to receive SSI, the asset test, is that if you're single, you can't have any more than $2,000 in assets. If you're married, you can have $3,000. We don't include, for purposes of deciding whether someone has this amount of money or not, we don't include their home, a car, personal property, and a couple other things. Now for SSI, the Social Security Administration looks at income in one of four ways. They look at income as either earned income, unearned income, in-kind support, or in deemed income. So we're going to take a look at how this would impact the individual's SSI benefit. SSI is really a monthly income to the individual. Okay, it's a federal and state combination in some states of income that person gets, and the SSI is intended to pay for that individual's, all of that individual's food and shelter. $771 is intended to pay for that individual's shelter and food. That's the federal level. Some states, if you're lucky enough to live in California, for example, you're going to get an additional $100 to $200 on top of that to live on every month for your food and shelter. Here in Texas, you just get the federal amount, $771. So when the individual who is receiving SSI gets earned income, they go and they work at McDonald's or wherever they're going to work, the first $85 is exempt for that individual. And then, because we want to incentivize them to go ahead and work if they can, we're only going to reduce their SSI by 50 cents to the dollar. So if they earn an additional $585 a month and they're receiving SSI, the first 85 is going to be exempt, so that leaves $500, and we're only going to reduce their SSI by $250. Unearned income is treated more severely. So if I give someone $585 a month, the first $20 is going to be exempt, and the rest $565 is going to be reduced from the SSI amount. So from the $771 they get every month, we're going to reduce it by $565 for that $585 gift. So think twice about gifting to an individual. In-kind support given to an individual. So this is this is where we're paying for that individual's food or shelter, which the SSI is supposed to be paying for. That's going to be treated with a formula. And I have written down the two names of the formula, but just for purposes of ease for today, think about it as it's either the exact amount that's provided for that person's food and shelter, or if it goes above a third of the SSI amount, then we're going to cap it at a third. Okay? So the reason this is so important is that that trustee of your special needs trust needs to understand the rules, because they might say, well, there's enough money in this special needs trust that I'm going to go ahead and pay for a really good place for my kiddo to live, right? I'm going to pay $1,000 or $2,000 knowing that the SSI is going to be reduced by up to a third, and it's still worth it. The last kind of income is deeming, and so this is where a parent's income is deemed to the child and the spouse's income is deemed to the spouse. That's 100%, that's why most children under the age of 18, their parents' income is deemed to them, and so many kids are not going to be eligible for SSI. SSDI, again, is not needs-based. So in order to receive it, there has to be some work record, whether it's the child's own work record or the parent's work record. So the disabled person's parent can actually be the work record as long as that parent is retired, disabled themselves, or has passed away. SSDI benefits will reduce your SSI income. Okay, and then again, just to reiterate, the thing about SSI in most states is that it gives you automatic eligibility for Medicaid, which is that medical insurance which so many of our disabled loved ones need. So there's a few other options that I want to quickly touch on before my time is over. And when you have a child or a loved one who has a special need, they may be able to set up an ABLE account. And again, this is a great tool for providing independence, self-autonomy for children or people who have disabilities. ABLE accounts were, I think, ABLE stands for Achieving a Better Life Experience, and I believe the legislation went through in 2014, I want to say. A lot of states in the United States have come up with these accounts. Texas has one, and California recently has one. I think Iowa is another state, but there's several states that have them. In order to be able to have an ABLE account, you had to have your qualifying disability before the age of 26. So if you're on SSI or SSDI, that automatically proves that you have a qualifying disability. So you automatically can set up an ABLE account because of that. Otherwise, if you're not on SSI or SSDI, you have to get a certification from a doctor in order to be eligible to set this up, proving that your disability occurred before the age of 26 and that it is a qualifying disability. There's a limit to how much you can put in these accounts. In Texas, it's $370,000. Every state is going to be different, and the amount is going to be capped at whatever that 529 plan in that state is capped at. So they go hand in hand. Up to $15,000 a year can be put into these. Oh, I want to go back to number 2. The limit in the account, even though like in Texas it's $370,000, it might be a high amount like that. If you go over $100,000, you're automatically ineligible for SSI. So if you want to remain eligible for SSI, you need to keep $100,000 or less in the ABLE account. The accounts are non-taxable. They can be used for qualifying expenses only if you want to maintain eligibility for SSI. And qualifying expenses, education, training, medical, lots of reasons, travel, it goes on and on. They are available in Texas and many other states, and the great thing is the ability to control these. And I guess my time is up, or do I have one more minute? Okay. There's one other tool that I'll just mention very briefly, and that is, I only know of it as the TrueLink card. There might be other credit cards that have this ability, but if you have a special needs trust that can be set up with a credit card, and you can do it with a TrueLink credit card or something similar, the credit card company gives you the ability to set the limits on what the card can be used for. So this has been great in cases where I've seen the beneficiary of a special needs trust have the ability to go purchase their gas, or go to a movie, or go to shopping for their clothes without having to have the trustee of the trust do it for them. So it, again, provides some independence, and the trustee has set up these limits that you can't buy food with it, and you can't, buy alcohol. You can set up your terms with the credit card company. So that's a really helpful tool. And I'm going to hand it back over to Julia.
Thank you. Well, as you can see, there's just a lot of different aspects to planning for your special needs child and making sure that your estate is integrating in. And we want to position your child so they have the best quality of life possible, that they really are thriving. And proactive planning is always the best planning. If we have to come up and clean up a mess afterwards or something that hasn't been done, we don't have all these options sometimes. And so this really, or they're disqualified for a period of time. So just proactively planning for your child and being here, I know I'm preaching to the choir really, because you're obviously thinking about that. And so this proactive planning will provide you that peace of mind that I know you all want for your child. Now, you have received some information, brochures about special needs trust and some guardianships, because we wanted you to have some information. I know there's not a whole lot of time for questions. Do we have a minute or two? Maybe one question. But we will do some drawings, and if you put that back there, we will call you, because I know there's not much time. Yes.
Thank you so much for the information. It was most helpful and informative. My question is, can a parent in their last will and testament name as a successor who they want the legal guardian to be, with not having to go through the probate court for that individual? So in other words, avoiding probate court by naming your future successor's legal guardian in your last will?
So in the trust, you'll be naming successor trustees that would do it. Now, guardian, you can state who you want. Say, like we have a guardianship of the person. You can state in a separate document who you would want for that. And that's going to be probably the best evidence for the court of who's best for that position. And so they would have to apply to be appointed as successor guardian. So it wouldn't avoid that step, because the court's going to have to notify them, or, basically bless that and give them new letters of guardianship. But it streamlines the process so much to have those letters, the declaration of who you want as a guardian for your child in the event of disability. So I do that as a separate document, so it's not just in the will or living situation. And this is who you want, and it's easier to change, so it just makes it a good document for that kind of thing. But I would say it's probably, we call it prima facie evidence, but it's best evidence of what you want, and that's going to hold a lot of weight in court.
Wonderful. Thank you.
Well, why don't you join me in giving a round of applause to Julia Dean and her team. Thank you so much for joining us. They're going to stick around during the break, so if you want to join them, they have a table set up. It happens to be near, we have the raffle. We have the raffle first, but they have a table near the desserts as well if you wanted to have a snack. So they have the best spot in the house over here.
You want me to do the raffle now? Okay. Okay, so we do have, let me just put it here. We have a gift basket. And this would be for number, get in the light, 954067. So 067 is, and Lindsay Masick. Great. So there's a gift basket waiting for you on, oh, there she is. She's going to bring it. Okay. And then let me go ahead and do another one. So we have a gift card, and this is for Olive Garden, and the ticket number ends in 4059, and it's for Jessica Cabas. Great. Awesome. Congratulations. And then the last one is for a free consultation and $250 off planning, so that's a $600 value at the Dean Law Firm. And it ends in 060, and it's Jessica Henderson. Do we see her? Oh, they're together. Oh, great. Good. Congratulations. Thank you all.